Thank you, and good morning, everyone. And thank you, Kelly, for the introduction. I'm sorry, I will have to speak in English, I promise. I will try to speak slowly in the 20 minutes that I have been allocated to speak about data protection laws, and the latest being Decree 13 on data protection and go back, yeah, forward. Sorry, I have to go forward, yeah. That's what I did. Okay. So thank you. Sorry about that. So Vietnam has actually issued a comprehensive regulation regarding data protection in April with the effective date of 1 July 2023. And so it requires, so basically what it has is that companies, businesses, individuals will have to pay attention to it. So before I launch into it, I just wanted to let you know what I will be covering. Briefly, an overview of the legal framework and particularly Decree 13, Decree 13, and finally about what businesses, people who have to comply will have to do to be able to comply with Decree 13 and other laws that have data protections and privacy specific provisions. So the first question you ask is why should I be looking at protecting personal data that I collect? The reason being that right now, the pandemic has caused everyone to understand the importance of the digital connectivity. So essentially, a lot of personal data flow through the digital networks and is very, very prone to either leak or abuse if this data is not protected. So the digital economy is one of the prompters for there being a heightened awareness that data protection has to be covered, like how Kelly has just mentioned a while ago. So data is also used by companies for various reasons. One of the many reasons is actually to understand the behavior of their customers to improve their product and service offerings, as well as to ensure that they can retain their clients and increase their own output. And the other thing is, of recent years, like what Kelly has mentioned, a lot of young adults are using the internet these days. So this means that they need to be able to trust that any network that they access and provide, and anyone they provide information to, will make sure that their privacy is protected and are confident to use those websites or also products of the businesses that are trying to lure them to their business. So trust has become a very important aspect of doing business in this digital environment. And with this, the governments, not just in Vietnam, but all over the world, have recognized the importance of having data protection laws, because they realize that individuals are not capable of protecting their own personal data themselves. And so as a consequence, many countries have passed data privacy laws. The first landmark law was in the in the EU, known as GDPR. And I'm sure most of you have heard about the GDPR, and that came into effect about maybe 5-6 years ago. So that was the starting point. And since then, many countries have passed data protection and privacy specific laws and regulations, and Vietnam is no exception. So I am just going to give you a general overview of the data and privacy protection legal framework in Vietnam. So prior to Decree 13, there were many data protection and privacy specific provisions in various laws. It was scattered all over. But so you will find a whole list of them, as I have set out in this slide. The main one to know is that the Constitution recognizes that the individual is entitled to the right to privacy. So what does that mean? If they're entitled to the right to privacy, that means that if I have their personal data, I will need to make sure that I protect it so that their privacy right is secure. So this is very important to understand that this is a right of every individual to have their data and to have their data dealt with properly, securely in accordance to their wishes. And so Vietnam has also signed a couple of treaties with other countries guaranteeing and assuring that they will comply with these requirements, where they will handle data, they will ensure that their citizens handle personal data in accordance with certain practices, best practices. So there are two recent laws, one, as I have mentioned, Decree 13, and there's also another Decree 53 that requires the implementation of cybersecurity. So data protection does not come in isolation. It also has to be with ensuring that when you operate in the cyberspace, you are actually ensuring that whatever operations that you have been secured. So that is also very important. So I will go quickly into the main principles of the Decree 13. So first of all, to know who will be involved and who will need to pay attention to Decree 13. So every Vietnamese agency, organization, and individual who handles personal data, who collects personal data for their activities will be covered. And so they're not just those who are based here, but also those who are based overseas. And foreign agencies, organizations, individuals, not-for-profit, NGOs are all covered, so long as you collect personal data. So the main driver here is the data owner, the individual. That's their personal data. So they are the drivers. They are actually the main points, alongside the government that has implemented some rules to ensure that these their rights are actually secured, and also to ensure that there is compliance with certain laws to ensure that the data subject's right and right to privacy is protected. So then the question is, if you are collecting data, what is your role? So the decree has distinguished 4 different roles. The first being data controller. A data controller is a person who collects the data, decides how this personal data is dealt with. So that's a controller and the key person. And then the other one is a processor. Processor means someone who will process data. Process can include using it, assessing it, analyzing it, in any way. So it's a very broad spectrum of activities that will be under processing. And so this, the processor would typically process the data under the instructions from the controller. So the controller controls how this data is going to be used. The processor will follow those instructions and process the data. And then there's also another one that is a combination, controller come processor. This is quite likely something that happens in most organizations and businesses, where a typical example would be the marketing team collects personal data, information about individuals who are interested, say, in banks to apply for a credit card. And this information then is given to their back office to process. So in that same organization, you have different departments operating and different activities. So the organization itself would be considered a controller and processor at the same time. Third parties are actually parties other than all these 3. Basically, they are the network providers. They are the pathways for the data to flow through from one point to the other. So each of them have different obligations, and these obligations are clearly set out in Decree 13. When I say clearly, broadly, but set out, and the distinction is clearly made. And so for each one, they have different obligations. Most of the most significant being the controller, because this is the person who collects the data. So then the question is, what is personal data? So most countries have defined personal data. Some of them have left it general. But in Vietnam, we have a description of what falls into basic data and what falls into sensitive data. Combined, they are all referred to as personal data. So if you are processing basic data, then you have certain obligations. Sensitive data has higher obligations as well. And we will come to that in a minute. So of note and of interest is that if you are handling any account information and health data of any individual, then that means you are processing sensitive data, not just basic data. So just bear that in mind, because then when we continue, you will understand where your obligations lie as well. The other thing is, this is something that is actually quite fluid, and it changes, and every business would operate and use personal data in different ways. So instead of stipulating specific requirements when using the data, Decree 13 has adopted a principle approach. So basically outlining that these are the principles that you have to pay attention to when processing data. For instance, the first one, you have to make sure that whatever data you collect is lawful. So you can't just collect any data. So one of this, and then the second one is that whenever you collect the data, the individual has to know what you're using the data for, how you're going to be using the data. So basically the W's, why, what, where, how. And then when you collect data, it should only be for the purpose. So for instance, if you are hiring someone, you do not need to know about how many family members they have, for instance. So that's excessive data. So you have to make sure that your data is limited to what you need and do not collect extra data. And that's also linked to the next one, that you must make sure and consciously make an effort to make sure that you are collecting only data that is relevant for what you intend to do. And so whenever collecting data, you have to make sure that it is accurate, and where it is not accurate and you are informed that you need to update the data, you have to take steps to update the data. One example would be the marketing department would call me Amarjit, and the processing department may forget to add my surname to it. So my name is probably the same as maybe, like I guess in Vietnam is probably the Win, for instance. So they have to make sure that the names are actually entered correctly into their systems, so that there is no chance of this information being used incorrectly. And security and confidentiality, I've mentioned that you have to make sure that whatever data you collect is stored and protected with the necessary processes, for instance, encrypting, anonymizing, to make sure that this data is not easily accessible to third parties. And retention is a very important point, because when you have data, you have collected data, then you have to ask yourself, how long do you need to keep it? Because sometimes the law would ask you to keep it, like for tax, for instance, you may have to keep it for 10 years plus. So then you have to ask yourself, am I keeping data for longer than what I need, for the purpose that I need? So that's very important. So you will have to look at what are your retention policies within your company. And so compliance, of course, they have to make sure that they comply. So those are the principles. They are not laws, they cannot be actioned, but these are the principles that the enforcers will look at when investigating any possible complaint or breach. So each, as I mentioned before, each entity, each person has a different obligation depending on the role that you have. So if you're the controller, you have certain obligations. You have to obtain the consent of the individual and provide them with proper notification of what you intend to do with their data. And then only obtain the consent. The consent here can't be that you inform them. They have to actively tick and agree that this is what they agree to. So they have to be informed. It has to be clear. It has to be in as simple language, I guess, as possible for them to understand what happens and how you're going to be processing their data. And another important point is that the data subject, the individuals are given certain rights. They have the right to come back to you and say, we want you to stop using our data. We want you to remove our data. So you have to have a system in place to be able to address those requests as well. And if you have issues, if they ask you to remove their data midway, in a transaction, then you need to notify them that if you continue with their request, what are the possible consequences and what may occur. For instance, you cannot continue with their the contract, or you cannot complete the transaction that they have requested you, so that they are aware and they can make a decision whether this is something that they want to continue with. And if there are any breaches, you are required to notify the authorities. So there is a timeline of 72 hours. This is a bit controversial because it's when you become aware. So therefore, your systems have to be in place for you to be able to identify or detect any breaches. And then the most important thing is, like Kelly said, that there are a whole bunch of young people who are currently using and operating in the digital environment. So whenever offering them any products, you need to know what their age is, because there are certain obligations for you to obtain consent from the parent for kids below 7, children below 7, and from 7 onwards, you have to get both the child and the parent's consent. So these things have to be in place. So Kelly, to somewhat, maybe this will help address the concerns that you have raised as well. And the companies are required to maintain a log of what they do, so that if there's any investigation, you can go back and check how you have been processing the data and be able to provide a rationale for processing the data. And another thing is, if you are processing sensitive information, and if you are sending this information, personal data, overseas, then you are also required to file these activities, your intention to, sorry, not your intention, you can commence the activities, but you're supposed to file within 60 days an impact assessment and information about what you are doing to the authorities as well. So I believe that yesterday they had a briefing that they're setting up a filing system online. So hopefully these you will be able to file this online instead of physical documents. So the format of the dossier is provided for in Decree 13. The impact assessments, the minimum content is prescribed for in Decree 13 as well. And in addition to that, you also have to make sure that you have proper governance framework for data protection. So the next one is for processor. The processor has slightly lesser obligation, and so they will, as I mentioned before, they will process data on behalf of the controller. They need to have a contract in place stipulating how the personal information will be processed. And even if their processes result in there being a breach, then they need to quickly inform the controller, who can then comply with their obligations under the law to notify the authorities. Similarly, when processing data, they need to be mindful of the age of the individuals that they are processing the data for. Also need to have a log of all their activities, and both for the controller and processor, unless you're a micro firm or a startup, you will need to have a data protection officer or someone who will be handling all matters relating to data protection and privacy within your organization. So for the third party, they also have to implement similar systems, and also have logs, etc., quite similar to what a processor will do. So each role has defined obligations. So as always, how do we ensure compliance? The ensuring compliance is by making sure you yield a stick. So a day ago, the authorities had actually the government issued a draft decree on administrative and cybersecurity violation. So if we look at, although the violations for data storage destruction is just 50 million to 80 million, for some of you may think it's not a large fine, but the other violations have got more stricter and higher penalties. For instance, where you sell personal data. And also you conduct cross-border transactions without having complied with all your obligations under the law. So it's up to 5% of your total revenue generation or profits as a consequence of the violation. So there is incremental penalty system. And so the most, I think for the probably systemic and continuing violations, the authorities can even ask you to suspend your data processing for 1 to 3 months. This would directly impact your business and operations. And a revocation of license, I think this is for very severe violation, and also seizure of income arising from using personal data unlawfully. So there's a range. And companies can decide where they want to sit in that range and how they want to assess their risk as well. So this is the part that I want to spend the next five minutes, I believe, to talk to you. So here, just to wrap up, the first thing is, what does Decree 13 ask of people who are processing data? First is to identify your role. Are you a processor? Are you a controller? Are you a combination? Are you a third party? The second thing is to understand what data you are processing currently. You are processing personal data, but is this personal data basic data? Is it sensitive data? Because each one will give rise to different obligations. The third thing is, do you have systems in place to handle data subject requests, to handle breaches, to detect breaches, to secure? Do you have a governance framework where you have policies in place to help you do all the 4 things that I just mentioned a while ago? So that's important as well. The next point is, who are the people authorized to access personal data? Does everyone have access to personal data? And those who have access, are they the right people to have access? And do they know what they can do with the information when they access such personal data? And then the next 2 things, if you are processing personal sensitive information, and if you are sending personal data overseas, then have you prepared your impact assessments to be ready and able to file it with the authorities within 60 days of you commencing such processing activities? So these are the few overall things that you will have to bear in mind. So how do you then implement it? So we're suggesting that you have a team, maybe a couple of individuals. For instance, your human resource person might be important because they process a lot of personal data. And so to set up a team of people who have and touch data in your organization. And then to train the staff, although this is not explicit in Decree 13, this is important, that your staff, your key management, and also anyone else who handle personal data is aware of this obligation, so that the organization as a whole is able to comply with Decree 13. And I have just mentioned identifying activities, knowing where, how you are processing the data, what data is coming in, personal data is coming in, how is it collected, how is it processed, who handles it. So all the W's. And the next thing is the first step you can do is then look at your personal data activities and then assess, does it comply with Decree 13? Does it not? So the generic term for it is do a gap analysis, to find out if there are any gaps in your current practices and whether you need to then update your practices so that you are compliant with Decree 13. Finally, then if there are any gaps, you want to then put together a plan to remediate and also make sure that this plan is implemented and in a systematic way, so that you are able to meet your obligations under Decree 13. So with that, I'm sorry, time is short, but you can have we will be able to talk again afterwards during the Q&A session. And thank you for your time. Over to you, Kelly.